Welcome to the Roberts Law Office Injury Podcast. Kentucky attorney Jeff Roberts has over 25 years of experience. He'll provide answers to your questions related to personal injury and automobile accidents, workers' compensation claims, and Social Security disability benefits. Let's join Jeff for this episode. Ladies and gentlemen, we are back with attorney Jeff Roberts here in Calloway County, and today we're going to talk about premises liability. This was when somebody might get hurt or injured in and around an apartment complex, multifamily dwelling. Jeff, welcome back to the conference room, buddy.
Hi, Jim. How are you?
Buddy, I'm glad to be here. This is a topic we've been talking about for a while. I think if you look at the economy and as dicey as things are getting, I think people are thinking, well, I could either buy that home, but the interest rates are going up. Maybe I'll just camp out in an apartment for a while. And I think because of that, this is kind of a timely topic for you, because you've dealt with these premises liabilities cases and claims for a while. In fact, a while back, we actually did a separate episode dealing more with a slip and fall at, say, a Walmart or a Kroger or some other business-type location. But today, we're really going to talk more about residential-type dwellings. So let's kind of jump into this. And how do you want to tee it off?
Well, I guess we'll tee it off to start with that, a lot of the law is very, very similar as far as what the law says from that standpoint between a residential property on premises liability and a commercial property business. The owner of the property has to keep their property in a reasonably safe condition for the people that are invited onto their property from that standpoint. So if in the standpoint of a business, like we've talked about, the customers that come into that business, it has to be in a reasonably safe condition for those individuals that are coming in to shop in that store. In the residential area, especially in a multifamily unit, an apartment complex type unit, which we have several of here in Calloway County, then the owner of that property also has to keep that property in a reasonably safe condition for the tenants, and others that are coming onto the property. The difference is that once you get into the rented spaces, then that changes things from that standpoint. So
I've actually come in through the front door, and now I'm inside the home or inside the apartment. Now it changes. Does the renter in that case provide a reasonably safe environment?
Correct. And then you're looking at the renter as potentially being the one responsible at that point in time. And the renter, the person who lives in that home, who is the renter, if they're injured because of an unsafe condition inside their apartment, obviously everything's going to some extent come back to what the written lease says, because by contract you can change certain things. So you'd have to always look at the lease itself and see how it's written. But as a general type rule, if you're inside the apartment that you are renting, then you're the one responsible for making sure that that property is in a safe condition. So if you've got a lamp on the table and then the cord that's dangling down in a walkway path and you trip over that cord yourself, then you're responsible for that injury.
You can't blame the landlord.
You can't blame the landlord in that kind of a setting from that standpoint. But the common area is what is commonly referred to as the common areas, which are the areas shared by all the tenants, so to speak, in the kind of the means of ingress and egress onto or getting onto or off the property. Those are still the landlord's responsibility to maintain those in a reasonably safe condition. So if the stairs are in disrepair, the railing for the stairs or something are in bad condition, and that causes someone to be injured, either a tenant on the property going back to their apartment or leaving their apartment, or even a guest of a tenant that's coming onto the property to visit or something, then that's going to end up being the landlord's responsibility from that perspective.
And so this would include the parking lot. This would include, as you said, common areas, so main walkways, stairwells, as you said. It could also be in the swimming pool area, right? The pool deck, and obviously was the pool safe.
Yes.
That area, is there a clubhouse? They would include all that. Also the laundry area, right?
Yes. Basically any area that the tenants are allowed to be on, all, not just one group of tenants that lives in this apartment, but tenants from different apartments are allowed to be at the pool area, the laundry area, parking lot, all of those are going to be what's referred to as common areas that would still maintain or be under the landlord's control or the property owner's control at that point in time, because the property owner is the one who can make the changes to that. The tenant in apartment 1A can't go make repairs to the stairway coming up to the apartment complex or to the parking lot or make changes to that. It's the landlord or the property owner's responsibility to make those changes and to make sure those areas are safe for someone to be in.
That's where it kind of gets dicey for me, because and I'm assuming this is a landlord issue. But you said that if I'm a renter and I invite a guest over, and the guest gets hurt, inside the unit, it's probably on me. Let's say they tripped over a cord or the vacuum or something like that, somehow got hurt. Well, let's say we're on a lot of these decks have a lot of these apartments have these little decks or little patios, and I'm leaning up against the railing, or my guest is leaning up against the railing, and it gives way. That's a construction issue. That is the landlord's. That's not mine, even though I'm the renter, correct?
Could be both.
Really?
It's going to depend to some extent on the lease from that standpoint. Those type of construction defects, generally you would look to the landlord from that perspective. And I say it could be both because everything in law, most everything in law is very fact dependent.
Right.
So
that's why you always say it depends.
Exactly, and I rarely speak in absolutes for that reason. But if the landlord has already told the tenant, say, look, there's a problem with this railing. We got a repair person coming. Don't use the deck. We're going to have it fixed on Tuesday, and it's on Friday, and we're going to have it fixed on Tuesday. And then the tenant lets somebody go out there knowing that it is, and they get hurt, then it could be liability on both parts.
And can that be verbal, or does that need to be written? If I'm the landlord, what's the way for me to protect myself in that? There's a termite issue, or maybe there's a structural defect of some sort. We see some water damage, that caused the support post to rot and things like that. I mean, typically, do I have to have that in writing?
Well, the best thing to do is to post something where the problem is at. You see, in a store, if they have a spill on the floor, the spill could be from another customer. The store employee may not have caused the spill from that standpoint, but they'll put a cone or something up to block that area and to let people know there's something here. Be careful, slippery, it's wet or whatever. And then you warn the person of that. And frankly, as a general rule, when you warn the person of a danger, if they proceed into that danger anyway, you don't have liability.
They're taking on the risk.
Exactly. So the best way to go back. It's not Kentucky no longer has assumption of the risk from that standpoint, but their job is to either correct the dangerous situation or warn you of the dangerous situation. So they've satisfied their duty of warning you of the dangerous situation. The same if it's a railing on a deck, the landlord needs to post signs on that deck. The railing is in disrepair. We're going to fix it. Don't lean against the railing. Don't come out on the deck. Whatever. To warn people of that problem so that they don't, and if they choose to ignore that warning, then that's going to ultimately be on them.
I remember in that previous episode, we were talking about, again, the grocery stores and places like that, and you just kind of use that example. Let's say some dish detergent or laundry detergent got spilled in the aisle. I mean, usually a store employee will, again, put that cone down. They may, rope it off or something just until they can get cleaned up. What about a common area in an apartment situation where you have a laundry facility and somebody has spilled liquid soap on the floor? I mean, I guess that needs to be monitored by the landlord. And if someone were to get hurt in that situation, I mean, how does that seems a little different, because
it is a little bit different. You don't have as much monitoring responsibility as a store does, at least in my opinion. And I think that's the way a jury would see it as well. Especially here in Western Kentucky. And a lot of these comes to, ultimately what a jury would decide is reasonable or unreasonable. If you had detergent spilled on the floor in the laundry room, and whoever spilled it goes to the office and tells them, and then 5 hours later it's still there, that's not going to be reasonable. If they spill the laundry detergent on the floor, and while they're walking to tell the front office about the spill, somebody comes in and slips and falls. It occurs 2 minutes after the spill has occurred. Jury probably is not going to say that the landlord is liable in that type of setting.
Not reasonable at that.
It's not reasonable. They didn't have the opportunity to correct the problem.
That's a good point. That's a good
from
point.
that standpoint. So
there was no negligence.
Yeah,
they didn't disregard
it wasn't foreseeable. They didn't know about it, and so all of these things come into play. Is in a grocery setting, it's common knowledge people are going to drop stuff on the floor. Things are going to get knocked off. And businesses are under an obligation to inspect and make sure that occurs from that standpoint, inspect to see if there's any kind of dangers there. And landlords have a obligation to inspect their premises. It's just not going to be as frequently, in my opinion, a requirement to do it as frequently as you see it in a grocery store where you have hundreds of people coming through in a relatively short period of time. Or in a apartment complex, you may have a lot of people coming through, but they also live there, so they're more likely to take a little more better care too.
Well, I would think a grocery store has more employees to be able to address it, whereas at an apartment complex, you may have the office staff, maybe one or two maintenance people running around for the entire development, if it's a larger development.
Right.
Let me ask you this. This is Murray, so we've got Murray State University here. Does this apply also to dorms and campus housing like that? I mean, is there a different set of rules for something that's, in this case, a state university?
There is some different rules in pursuing a claim against the state, because the state is subject to or has sovereign immunity, which means basically you can only sue the state in certain situations. And if it's if you're suing the state, first off, as the state itself is going to be immune from suit except for ministerial actions, which discretionary actions, they're going to be immune. If it is a mandatory thing that they do, then that changes, and so they can be liable for not doing for not taking a mandatory action that they were supposed to take, or something of that nature. So you get into another area of law, sovereign immunity law, when you're dealing with a state university or any state actor. Now, that's usually the state itself that has the immunity, not the individual employee, and that's the reason a lot of times you'll see, the Commonwealth of Kentucky would not be sued, but maintenance man Joe ends up being sued because he doesn't have the sovereign immunity. The state's the one that has the sovereign immunity aspect of it. It's
a lot more complicated when you have a state entity involved.
It gets a lot more complicated, and they have qualified official immunity and the whole of the immunity aspect with the state. You've got to, whenever I'm looking at those cases, I've got to go through and look at a host of immunity type issues to make sure that there's going to be a claim there that could actually be pursued. There may be negligent as can be, and it'd be easy to establish negligence in my client's damages, but if they're immune from suit, it doesn't make any difference.
Right. It's a shield that we can't get past.
Correct.
Okay, that makes sense. I want to circle back. There are a couple more things, obviously, with the multifamily dwelling, but I could see this on a campus, and I could also see this in an apartment complex. If there's an action, let's say there's some kind of an assault or something like that, in a parking lot or in a stairwell or a hallway, that trips more over into criminal, isn't it? I mean, that's not necessarily the landlord's responsibility. That would be a criminal action, which is a different kind of law between the assailant and the victim, right?
Yes.
So that's kind of outside the purview of what we're talking about, but I think it's an interesting distinction.
It is an interesting distinction. Obviously, whoever perpetrates the crime could have civil liability as well as the criminal liability for the crime, but there can be liability for the property owner in those settings as well if they knew or should have known of that dangerous condition. So if they allow, we're going to go to an example of, frankly, and I'll use, I won't mention any communities or anything, but when my daughter moved away to go to school, away from Murray to a different school to go to law school, when we were looking at apartment complexes and homes for her to potentially rent and live in, they're one of those because we were looking at reviews and things of that nature, and one of them said if you are comfortable with drug dealing in the parking lot, this is the place for you. And so we obviously did not go there, but if drug dealing is taking place in the parking lot and the property owner, and it's so well known that it's being shown up on reviews that you can find on Google and things of that nature, and the property owner is not taking steps to rectify that problem, and then a tenant comes home and walks by a drug deal and they get scared, and then the drug dealers take some kind of action and hurt them. Yeah, then the landowner is going to be responsible for failure to maintain a safe place because they had a reasonable knowledge of this criminal activity, and it's fairly common knowledge that if you got people walking by where criminal activity, especially drug dealing, is going to take place, it's likely somebody's going to get injured. And so if they don't take steps to correct that dangerous condition on their property, it's the same as having and from my standpoint, I think from the legal standpoint, it's the same as having if they know one of the stairs, the wood in that stair is rotten, and they just paint over it instead of replacing the stairs, they know they got that dangerous condition they didn't fix. The same with the drug dealing in the parking lot. If they didn't fix that dangerous condition, then they can be and should be liable for the injuries caused by that.
Well, in what comes to mind for me is when you have poor lighting or inadequate lighting. So you've got a lot of dark areas that it's a common area, and it just presents an unsafe environment or a potentially unsafe environment.
Exactly. In that, if you have unsafe lighting in the stairways and causes somebody to trip and fall because they can't see the stairs well or something of that nature, they're going to be liable. And it's the same with outdoor areas. If the parking lot is not very well lit, that's going to encourage criminal activity to some extent, depending on a lot of other things, but at least it can play into it. So fixing the lighting in the parking lot can help to eliminate that, because that tends to occur in darker areas, and criminal activity tends to occur in those type of areas as opposed to very well lit areas as a general rule.
Right. So not only is a well lit area aesthetically pleasing, but it's also probably more secure.
As a general, yes.
Yeah. Which brings me to the next one is inadequate security. I mean, we've talked about that a little bit. A lot of times you see these buildings where you have to be buzzed to get in, and maybe the door is locked so anybody off the street can walk in, and maybe it's not monitored. So you don't have somebody sitting at a desk or something saying, hey, who are you here to see? And suddenly somebody gets in and causes problems. Again, we kind of come back to that assault example, to where maybe they just stole stuff, but maybe they hurt somebody. And I would think the landlord would, hey, if I knew that door was broken and it was, free access to everybody at that point, I think I've assumed some liability there.
It certainly could be in that setting. If it's a door that is normally locked and they know the lock is broken and they don't repair that, then that could cause some liability or establish a liability on the landowner from that setting. I don't know, and I think again, a lot of this comes back to the community, the jury, and all of that. I don't know that, like in the community I live in, Murray, I don't think the jury would say, yeah, an apartment complex needs to have a locked door and buzz people in.
Right.
In this community. Now, if you go to a different community, I suspect that's fairly common in New York City, for instance. And so that may be a standard of care that the landlord has to take in that community versus not having to take that type of care in Calloway County or in Murray, just because the crime rate is vastly different in the number of people in the community and passing by is vastly different. So
right. So again, coming back to the security issue, and this is all in the vein of premises liability. Is the landlord or property management company liable for something that happens on their premises? are they required to have security guards roaming the property and things like that, or is that just a service and kind of an amenity? I would think that's more of an amenity to make the tenants and potential tenants feel more comfortable and, hey, this is a nice place.
Well, and again, it comes back to the same issue about buzzing people in. It's going to be what is expected and what do you see in that community. I think that having security on the premises in certain communities is going to be certainly a requirement from that perspective that could impose liability if they don't have that. Whereas in other areas, it's not going to be a requirement. I don't like it.
Right. Well, if it's a common entrance, like it's a big tower, it's a high rise where everybody's going up. I could see a locked door that you have to come through. But if it's an apartment building where you just drive up and you walk in, to this unit or that unit, it's almost like a motel, right? There wouldn't be a buzzer out there, because you've got access to each of the individual units. So it's a whole different game depending on the community, right?
Yeah, it depends on the type of structure that it is, in the overall community as well.
Yeah.
I mean, if you're in an area that is that it is a high crime area, and then having security may be a requirement in that area. That may be what the standard of care is for that area.
That's a good way to look at it. Standard of care.
Yeah. For that area, a reasonable landowner or owner of an apartment complex would have security in this setting or in this location. And if that's the case, then there could very well be liability from that perspective. And I've gone to communities where even grocery stores have security guards,
right?
From that standpoint, and here in Murray, you don't see that, but then there are some communities that is very, very commonplace to have a security guard at the grocery store, and we hear of people being injured from criminal activity at grocery stores. And so if you're in a community where that's a common occurrence, then that can impose liability if you don't comply with that, what is standard for that community.
Okay. So. Well, we've got a few minutes left in this episode. Let me kind of change the perspective on this now. Let's say I am a renter and I'm in an apartment or a duplex or a triplex or a quad, and I am injured. What are the steps I should take? I mean, do I need to notify the landlord? Obviously, do I go to the hospital first? Do I call an attorney? I mean, what really should I do if something does happen? I fall down the stairs, going to the pool. I mean, that kind of stuff.
Well, obviously, first thing to do is get medical treatment. And so, if you fall or are injured in any form or fashion, seek medical treatment. That's the first thing. I've seen ads at times where people say, well, call a lawyer as soon as it happens. Get help, get medical help.
Right.
From that standpoint. And if it's a condition that people aren't likely to see, let somebody else know about the condition so that hopefully it will get fixed and nobody else will get hurt as well. But after you've gotten the medical treatment for the condition, then it's a good idea to obviously let the landlord know about the injury, and so you can find out who their insurance is, and also to reach out to an attorney at that point in time to find out what your rights are, because the landlord's first call, property owner's first call is going to be to their insurance company, and their insurance companies are going to know what the law is. They're going to know what their rights are from that standpoint, and they're going to start working to limit the property owner's exposure and the insurance company's exposure to damages at that point in time. And so, having someone that you can talk to, and most of the time you can call a lawyer and talk to them about the situation. Most lawyers, and myself included, will talk to a potential client for the first time without any charge whatsoever. The initial evaluation, there's no cost to that, so you can come in and sit down and talk with me, and we can talk about your situation, and I can give you my thoughts on it, give you my advice, and then you can say, okay, yeah, I want to hire you or I don't want to hire you. That's your call after we've had that conversation, and there's no cost associated with that aspect of it.
No cost, no obligation.
No cost, no obligation from that standpoint. And in as far as letting the landowner know, a lot of times, even if you don't think that the landowner was negligent, you may still want to notify them because it very well may be that their insurance, a lot of premises liability insurance, has a med pay provision that it will pay medical care for someone injured on the property up to a certain dollar figure, regardless of whether it was as a result of negligence of anybody. So if you trip over your own 2 feet, they may still pay for your medical bills if it occurred in a common area or in a parking lot or a residential property, even for that matter. So that med pay may still kick in from that standpoint. So if you have medical bills and you're not sure how to pay those medical bills because you fell on property, at least it's something to look into from that standpoint. But
But you should at least notify the property management company, the property owner. Hey, this happened.
Yes.
I would think like a car wreck. If possible, if you're able to do so, get some pictures of the area before it gets magically repaired, or
Right.
that stuff happens a lot.
Yes, documenting the issue, and if what you will sometimes see as well, if you fall, and then especially you'll see this I've seen it in the apartment complex setting, where a person's gotten injured on the property, and a week later they're there at the property again, and another tenant says, "Oh yeah," I said, "I heard got injured on that step. I've been telling them I've told them 2 times that I've tripped over it twice, but luckily I didn't get injured. But I've told them that they need to fix that step 6 months ago, and they still hadn't done it." And you get that person's name, and contact information, because that's further proof that they had knowledge of the dangerous condition. So, documenting the condition itself, and then if anybody comes to you and says, "I've already told them about this,"
Right.
Then make sure you get that person's name, contact information, so that your attorney can later contact them, get an affidavit, get depositions, document that that information was conveyed up to the property owner, the front office, and steps to correct it weren't made, so that it's even further evidence of negligence on the property owner's part in that regard.
That makes sense. And I would think, again, coming back to a car wreck situation, sometimes that first day or two, I'm just going to go home and see how I feel. But a couple of days later, I've noticed I'm just not feeling good. So now I'm going to go to the urgent care. I'm going to go see my primary. I probably ought to say when I see them, "Hey, look, I fell down at my apartment." You want to get that documented, I would think, into the medical record, right?
Correct.
Because
You want to get it documented that you tripped and fell, or whatever it was that caused the injury, and it's best to tell them where, if you can. I tripped on steps at my apartment complex or whatever.
the insurance company is going to say, "No, you did this somewhere else. You're just trying to blame it on us."
They're going to try to say that for sure. Or
I
if you
would
don't,
think so.
if you don't say that, if you just go in there and say, "My knee's hurting," and I was vacuuming today and my knee's hurting, they're going to say that had nothing to do with your fall. You related it to vacuuming. So
they may not have known you actually fell 2 days earlier because you were just talking about vacuuming.
Exactly. Yeah. And so it may have been bothering you for a while since the fall, and then the vacuuming it made it a little more painful. And you say, "Well, can't even do my household chores now. I need to go see what's going on." So that may have been what triggered, okay, I need to go get medical treatment. But what caused the injury itself was the fall. And so, you need to relate that to what started the problem to the fall. And if you're vacuuming and you twist and you hurt your knee, then obviously tell them that vacuuming is what caused it. And if the fall had nothing to do with it, then you don't mention the fall. But if something, whatever triggers it's what you need to tell the doctor. And for a couple of reasons. One is documenting it in case there is something that goes on further. But you can be injured differently from a twist injury versus a fall on a hard object where you're striking your kneecap. It can be two different types of injuries, and it helps the doctor to narrow down what's going on too. At least that's what I've been told from doctors when I've asked them, "What does it matter how the injury occurred?" And they said, "Well, it lets us know." And most times they're going to ask you, what happened? How did this happen? And part of that is because it helps them to narrow down what could be the problem that's causing the person's pain.
That makes a lot of sense. Jeff, I appreciate the information on this because, again, with the economy being what it is, I think a lot of people, I know When I travel down here, I see apartment buildings going up left and right. And, I think, again, more and more people are looking at that as, for the next few years, this might be the financially viable, way to go, just because new homes are expensive. It's like cars now, even used cars, existing homes are getting expensive. Maybe the renter's the way to go. But I think more and more of these accidents and falls and things like that are potentially going to happen just because there's more people looking at them. So I appreciate the information. Now, I know last episode we actually announced the opening of your Hopkinsville location down at 1610 South Virginia. So again, your primary office is right here in Murray, but now, as a convenience to your client base, you've actually opened up a second office.
Yes, I am have an office in Hopkinsville now where I can meet clients up there, and as a matter of fact, I'm going to be there tomorrow meeting with clients, and so that is in it. I'm glad that I've been able to do that because I've represented clients in that area for some time. I mean, I've been doing this for 30 years, and I have clients all over that have had to drive for a long distance, but I've had a lot of clients up in that area, and I'm glad this opportunity's come available for me so that I can hopefully better serve my clients that I already have in that area, as well as the other residents in the Hopkinsville, Christian County, Tree County area.
In this kind of case, this kind of injury case, actually, you don't have to be in a certain county. I mean, you can handle these cases really all the way across the Commonwealth. I mean, this is the nice thing about injury law is the fact that as long as you're within the state boundary, because the legal license is state specific, so you're licensed in the state of Kentucky. I don't have to live in Murray or even Hopkinsville to talk to you. I could live in Madisonville. I could live in Somerset. I could live in Bowling Green and still work with you if I decide, I like Jeff. I trust Jeff. Jeff's the one I want to represent me in this claim.
Exactly. And I do handle cases all over the state in various areas of what I practice from that standpoint. And, I think that it's with one of the developments as a result of COVID was doing things remotely in video conferencing. And while it was present from FaceTime and things of that nature, it was not well used. But with Zoom and Microsoft Teams and Skype, it became much more common to do that to talk with people through that medium versus just over the phone. And I think it's allowed me, because I like face-to-face contact, and so and I think I've mentioned this before, when I'm talking to a client about complex legal issues here in the office versus over the phone, I can see from their body language if they're understanding what I'm saying, or if I need to explain it in a different way, in a more in a easier or more in a way that they can understand better, and I can see that. And with the video conference through Zoom, it's the same way. I can see their face, I can see their expressions, and if I can tell if I'm losing them, and then kind of come back and recover it again in a different way to make sure, because some of these concepts, and I've done it for 30 plus years, and then 3 years of law school before that to teach the concepts to me. So I want to make sure my clients are understanding it. I think that's while I know the legal concepts very well, my client is the ultimate decision maker, with me advising them what's fair and what's not fair, and what I think is the best option for them. But I need to give them the proper information so that they can make the best decision for themselves, because they know their home situation much better than I know their home situation. I try to get to know it as well as I can when I represent people, but I think that having those conversations and being now allowed to do that and able to do that with Zoom, and I have that ability, so any client that wants to, whether they're local and they just don't want to get out, if they want to do it by video conference, I'm more than happy with doing that, and I can schedule those very easily if clients wish to take that option.
Yeah, and again, as you said, I think that's probably the only silver lining of this whole COVID experience. But I mean, technology-wise, a lot of businesses learned how to use that, and I like the fact that your office in particular has really gotten skilled at that, and it makes it easy, I think, for the client, the potential client, oftentimes. And ladies and gentlemen, if you want to check me on that, by all means, go out and look at Jeff's Google reviews. Go look at the reviews he's got on Facebook. I mean, Jeff is an easy to talk to guy. And, the law itself is complex, but Jeff explains it in a way and makes you feel comfortable that, okay, I do understand this better, and I think I trust him. So, I mean, those Google reviews, I love referring people to them because you've got a long list of them, and they all kind of say the same kind of stuff. And congratulations to you. I mean, you earned those.
Thank you. I appreciate that.
Absolutely. Well, my friends, we'll be back in about 2 weeks, but I want to thank you for your time and listening. And if you'd like to find out more about Jeff Roberts, you can visit jeffrobertslaw.com. And by all means, you can check him out on Facebook as well. And until next time, this is the Roberts Law Office with attorney Jeff Roberts here in Calloway County.
Thank you.
Bye-bye. Thank you for listening to the Roberts Law Office Injury Podcast. Jeff will return in 2 weeks. Until then, he invites you to visit jeffrobertslaw.com and follow his firm on Facebook. At the Roberts Law Office, you'll find a history of small town service and big city results.